Welcome to National Inventor Club. My name is Brian Freed. I'm the founder, and I always find amazing guests to bring to us so we can learn how to be better inventors, become inventors from the start, or to protect our intellectual property. So today, I have Raymond Van Dyke. He is from Van Dyke Intellectual Property in Washington, D.C. And here's a question that I always pose that I asked Raymond to help us out with this evening. What is a patent? And what are the parts of a patent? Whether you're thinking about getting a patent, you have one right now, you open it up and you look and there's claims, there's drawings, there's summaries, there's references, there's so many different parts of a patent that can be confusing. So I brought Raymond in to kind of dissect it with us. Raymond, thank you for joining us.
Thank you for having me, Brian.
All right, so let's get started. The parts of a patent every inventor should know. That's the way we titled this. So let's begin. So Raymond, before we do though, why don't you take a moment and tell us about your background and tell us what you do at Raymond Van Dyke, Van Dyke Intellectual Property.
Yeah. Okay, well, I'm an intellectual property practitioner. I've been a practitioner for over 30 years. My background is in the electrical computer arts, and I have a master's degree in computer science. And I have been always a patent attorney, and I focused on that increasingly over the last 20 years or so. When you go into the big firms, it's generally litigation and things like that, but I focused on mostly on prosecution. I'm a fellow of the American Intellectual Property Law Association, which is the biggest IP group in the United States, and also a fellow of the American Bar Foundation, sort of like the ABA. All right. So I also teach. I teach intellectual property, the basics of it, and at the George Washington University in Washington, D.C. I'm the chair of the Licensing Executive Society for Washington, D.C., and also in other things. And also local bar associations and tech groups I'm active in.
Great. And I know that you've had me on as a panelist for the World Intellectual Property Day, right?
Yep.
That's also an interesting event that you do every year. I think you host that?
That I do.
Excellent. And how dedicated you are. You have a tie that I think you showed me before that looked like part of a patent or an inventing tie.
Yeah, it's the inventor's tie. You can purchase it at the patent office gift shop.
Very nice. All right. So Raymond, let's get into it. I know that you've put together a couple slides here to talk about what a patent is, dig deep into it so we can figure out what we have if we do end up having a patent. Here's one of mine that I happen to have on my table. It's a design patent. So we'll show some other ones, but yeah, let's go through it and figure out what the next steps are for us so we can learn.
Okay.
All right.
Very good. Okay, so why are you filing for a patent? All right, that's one of the big things. You've got the idea, you want to protect it, but what do you do? How do I begin the situation? So we're going to be going through the various parts of a patent application, and once it's on file, it enters into what's called patent prosecution, and when that prosecution is done, it is issued, and it goes into the enforcement period. So we're going to talk about the main parts of the patent and briefly about these various procedures. So with patents, it's a government grant. It is a right to exclude others. It's what's called a negative right. It is not a right to do something. You get a patent, it does not give you the right to do that. It gives you the right to exclude other people from infringing on what you do. Okay? It is a limited right in time and scope, 20 years from filing. All right. And the United States patent is limited, of course, to the United States itself. You can't extend the United States patent outside the United States. People have tried. So why are you filing for a patent? It's part of human nature. People are always, there's lots of tinkerers. And in my practice over the years, I've identified a lot of medical people. A lot of doctors are tinkerers. Dentists in particular, they're tinkerers. They like to get it. It's not just in their field. All right. They get to tinker on all kinds of ideas. So it's anyone having a new idea. And this could come from anybody. All right. Whether it's a new paradigm busting innovation that changes mankind or an incremental advancement, these are all potentially patentable ideas.
It's interesting, Raymond, because there's many people that are working on inventions, whether they're in their profession or they're people watchers, or
Yeah.
maybe like me, I find things that annoy me, whether it's me doing it or somebody else doing it, and maybe I can find a better way to do it. And that's how you can come up with an idea. So it could be anybody, right?
Yeah.
You're a doctor
Anybody.
and your lawyer, and anybody can come up with an idea.
Yeah. We're all human beings. We're all creative, and people have. You could just it could just spring into your mind and an idea. So, but our government encourages innovation. Small businesses, for example, and inventors get 50% off of the USPTO fee reduction. Micro entities, if you qualify for that, is about 80% now. Okay, the inventorship rights are really put into our Constitution. Our founders democratized the patent system. This is part of the reason why the United States is great, in my view.
You know, Raymond, I think on the slide you had earlier, I believe it was for when you were talking about what the right is
Mm-hmm.
with a patent. I think a lot of people get confused with that because it's almost like you can't infringe on my intellectual property, but you're saying it a little differently. If you can just touch on that, because I think it's really important for inventors to understand.
Okay. Well, let's say that you get a patent to do A plus B. Okay. All right. That does not give you the right. You still may infringe somebody who does A or somebody who does B, but they cannot. But you can start. But you may infringe their patents. But if you get a patent on A plus B, I'm simplifying this to the highest degree.
Yep.
If you get a patent on A plus B, you can stop anyone else, even perhaps A and B, from doing that. So the patent is not a right to do something in the patent. It is a right to exclude other people from infringing on your right. All right.
Thank you.
This is something that came up in the 500 years ago, or almost 600 years ago in Venice, that they first conceived of this type of right, and it's been with us ever since.
Great. Thank you. All right. I think you're on slide 7, right?
Yeah.
This one.
Yep. Yeah, there's different types of patents. There's utility patents, which is the main one we're going to talk about. There's provisional patenting, which is an informal way to pursue a utility patent. We'll talk about that. There's design patents, which we'll talk about in the next slide. And a plant patent is one of the really rare ones there. That's an example of one there. So you can get patents on certain types of plants, asexually reproducing plants. So these are not naturally occurring. You can't get a patent on a plant that's in nature. But you can get a patent on a plant that you splice or manufacture in some other way. Okay? And PCT is Patent Cooperation Treaty or foreign matters. So this is where you take your existing rights and you extend them outside the United States.
Great.
Okay, so let's talk about design patents a little bit. Here's an infamous one. Steve Jobs' design patent for the rounded corners of the iPhone. All right, so design patents are very limited. They're only for the appearance, how it looks, not for anything functional. All right. So if it doesn't look exactly like this, it cannot infringe this design patent. But let's look at another one here. This, again, it's only for the ornamental parts. Here, a friend of mine got this. He got a shoe, men's and women's, but I'm only showing the women's, where it has a bullet for the heel. So the parts of the design patent that are being covered are shown in darker ink. The things that are non-claimed are in broken lines. So they're not claiming a shoe. They're only claiming the ornamental part, which is the bullet heel. Okay, it's the aesthetic appearance of it. Nothing functional. If you want something functional, you got to go for a design patent.
So we can't, well, you have to go for the utility patent, right?
I'm sorry, you have to go for the utility patent. I
Yeah.
misspoke.
So with this design patent, it's only ornamental. I can
Mhm.
only show it based on drawings. If I want to describe it, I think the only place to really describe it is in the title.
Yeah, they have. Yeah, the title. That's in essence, and in essence, the description is: "I claim the following drawing."
Okay.
The invention shown on the drawing.
So not 100% as strong as a utility patent, which you're going to get to, but this one is more on the design and the shape, like you're mentioning,
Exactly.
and it has a little bit less of protection.
Well, for what it is, it provides protection for this appearance. So
Yeah,
if you have a specific product that has to appear in a certain way, a design patent can help you. If you have a product that has functions and can be implemented in different ways, this is not the way to get a patent.
understood. And this,
Okay?
I was saying and asking about the years that it covers. So this is 15 years.
Yeah.
Okay. And the utility you mentioned earlier was for 20 years
20 years from filing. So you
from
got to go through
filing.
the process, and then it's 20 years from the filing.
Got it.
Okay. So we're going to talk about utility from here on. Okay. So you're going to have an invention disclosure. All right. That's some idea written down. And then you're going to go into the patent application. It's going to be transformed into that. Then you file it in the US. You may go for foreign also. And after filing, it enters the prosecution phase. And the prosecution phase ends at the day of issuance of the patent. And on issuance, the enforcement period starts. Okay, so that's the whole patent process, 20 years right there. All right. So let's start from the beginning. You may be in a corporation, or you're in your own garage or at your own desk. So you have a write-up. So you got to do some kind of physical write-up. You've got to bring it down to earth, so to speak, make it tangible. Now, at some point, you should engage some kind of patent attorney. The patent attorney is going to contribute to this process. Patent attorneys are licensed or registered professionals. There's not just any attorney. I took a separate bar exam to be a patent attorney. Okay, so in that sense, if you're going to deal with the patent office, you've got to get a licensed person. Okay. Now we're going to talk about the specification, which is the full description of the invention. And then there's the claims part, which is the legal boundaries, the exclusivity I was talking about. We're going to talk a little bit about the strategy. Why get a patent? All right. You've got to figure out, well, why am I doing this? You get your advice from an attorney as well. Now, there's a difference between inventorship and ownership. Ownership can be assigned. For example, if you're an employee of a company, the ownership of that invention can be assigned to the company. But inventorship is you, and that can never be assigned. Now, there's publication and potential loss of right. These are important things. I include them here because this is probably the most important thing. We used to have a so-called grace period where you disclose the invention and then file for patent. Forget that. That's gone. All right. They've made changes to the law with the America Invents Act and everything that we're now pretty much a shift to a first to file. So you disclose on day one, on Monday, and you file on Tuesday, there is risk. Okay. So my only advice is to at least file a provisional patent, an informal patent, before it is disclosed to the world. Okay? Before you talk about it at a conference, before you publish that paper, before you give a speech somewhere about the product, before you put it on the internet or whatever. Protect it first, then talk about it. Okay?
So protect it with a provisional patent application.
At the very least.
At the very least, which gives you the right for 1 year to say that you're patent pending before you file this non-provisional patent or utility?
Yeah, provisional gives you 1 year grace period, so to speak. I shouldn't use that.
Yep.
1 year period during which you can perhaps seek funding, perhaps you can perfect the product or whatever, get market share. And at that point, within that 1 year, you must at that point convert partake of the patent system, convert to the utility patent.
Now, I still get people call me up, Raymond, that say, I have my idea in an envelope. I have it documented on my computer, wherever it is. I told my aunt, whatever. So you're saying that the American Invents Act stopped that, and now it's first to file, which is very important for inventors to understand before you disclose it. What about if I'm sharing that information with an NDA?
Well, that gives you some measure of protection. It gives you contractual protection. You can sue them for violation of the NDA, but the invention may be out there and it may have devastating consequences. So it better have the NDA better say, you got to pay me $10 million or whatever,
Right. And the NDA stands for non-disclosure agreement.
Yeah. Okay. Now, since you may be involving with the rest of the world is already okay with this first to file absolute novelty requirement. No, but let's say you were a Frenchman and you disclose the invention on Monday and then file for a patent on Tuesday. Gone. You've released it. Doesn't matter. It was you. It's gone. You've lost the right to the invention. So my advice to you is that even though we sort of technically have a grace period, ignore it. Just pretend that it's absolute.
Okay. Many inventors, Raymond, when we're coming up with ideas, we're very excited. We want to tell the world about our idea. And you're talking about the risk associated with just doing that. And it's better to kind of keep it tight, have somebody sign a non-disclosure agreement, even if you're in the middle of starting to put it together and work on it. It's better to just have that filing date, that the provisional patent application. But before I even do that, Raymond, many inventors kind of look online. They go to Walmart or they go to Amazon and they don't see their invention. They think that they hit a gold mine. So how important is it to do a patent search?
Well, it depends on the sophistication of the person. If you are a sophisticated person in the industry, you can go online and do your own search. All right. However, since we're not all sophisticated and everything, you can hire a patent searcher. And I know people and everything that can do that for you. So feel free to contact me and I can put you in contact with patent searchers. Okay. Okay, we're going to talk about the specification. Okay, the disclosure of the new idea. This is what's called a constructive reduction to practice. In other words, if you make the idea, if you create the doohickey or the app, whatever, if you create it, then that's a reduction to practice itself. The patent application is a constructive reduction to practice, which means that patent system doesn't require you to actually create the invention. All right. 150 years ago, they required a model on everything of the invention and everything, but they don't require that anymore. So you have the idea. The idea can be entirely in your head and not created, so to speak. But as long as you describe it in sufficient detail to meet the requirements of the patent system, that is adequate. In the specification, there are various parts within it. You have the background of the invention. All right. What do we know out there already? If we know about A and we know about B, then we can talk about that. They do this, but A does this, but they really don't address this other issue. B does this other thing, but they don't address it in this other thing. But A and B, which is the invention, we do. So you want to talk about what's known. Then you get into a summary of the invention, which is a paragraph or two, where you get into just briefly what the invention is about. Then you have drawings. If you have drawings, not all inventions have drawings. like in chemical cases, biotech cases, you don't typically have drawings as such. But, if you have a electrical device or mechanical device, whatever, you're going to have the drawings. So you got to have a description of the drawings. Okay.
Mm.
After that, there's the detailed description of the invention, where you get into the specifics of the invention, where you discuss how it works, all the different facets of it. If there are parameters in there, temperature ranges or angle ranges, or get into the specifics of then, along with the permutations, so to speak, or the variables. Okay. And the reason for that is, there's Supreme Court cases out there that you need to be, your patent attorney at least needs to be aware of, that let's say there's 4 ways of doing your invention. Well, you better describe all 4 ways. In the Amgen versus Sanofi case, which is 2003 Supreme Court case, the patentee claimed it in a chemical way, but there's like a million different possibilities. But in their specification, they only talked about 18 of them with any degree of specificity. So the Supreme Court said, well, you're not going to get the millions, but I will give you the 18 that you talked about. So in your specification, you need to address the different ways the invention works. Okay.
It's interesting, Raymond. There's so many people that come up with an idea, and you work with a patent attorney or a patent agent, and all of a sudden, when your application is in that draft, you realize that there's so much that goes into it, and you're going through the parts here, but many different twists and turns and ways, and try to make it broad so you can be flexible with certain things. And it's sometimes you could think about it and it's overwhelming, but that's why you hire a professional. I mean, there are people that can do it themselves, but this is almost like an art itself. And that's what's really interesting. You have one of your patents, not yours, but somebody's patent there. Let's just pause for 1 second and take a look. What does that look like, Raymond? So show us what we've spoken about so far on the inside.
Okay.
We talked about the illustrations. We talked about the description.
Well, the front page talks about the inventor and the specifics of that, the classifications of the invention. Then you're going to get into the drawings, and there's going to be, this case had a lot of drawings. And then you're going to get into the description of the invention, where you have related cases there, but the field of the invention, like I said, the background of the invention. Okay. And that, in this case, we talk about the background for a bit. Then we get into the summary of the invention.
Wow. Look at that. We could see it, but maybe if you could just hold it just a little bit closer and see how much detail is in that. So the 3 and the 4 on the top, those are part of the claims?
No. We're in the specification.
Specifications. Okay.
Yeah. And then there's the brief description of the drawings, and here's the descriptions of the drawings. I know we're not going to get into the details here, but we can't in this talk. Then I have the detailed description, and the detailed description goes on for a number of pages.
Wow.
And then it ends in the claims part, which starts here. And I'm not going to get into that because I have a claim in here. But the patent document comes out, and it has all of these parts to it. Again, after the detailed description, where you get into it at length, you can have the claims part, which is the legal part, the exclusivity rights I was talking about. And then it ends with the abstraction, similar to the summary, just an abstraction of the invention, which is used for a reference within the patent office. Okay. So let's look at a claim. What are these claims? He talked about all these aren't claims. And what's going on here? Well, claim drafting is an art and a science. I've had to take inventor write-ups, weird notes and everything, sometimes some Post-its and this, that, and the other. And I have to decipher what is the essence of the invention. Okay. And I have to bring that down from the abstraction land to paper. Okay. So it's generally going to be a system, a method, an apparatus, a composition, like in chemistry or whatever. I need to cover infringements. I need to cover the various types of ways that the invention can be infringed, so to speak. Alternatives, possible design arounds, so I can head them off at the pass. Also, avoid problems in common law. Like I said, there's been over the last few years, there's been an attack on the patent system with abstraction and things like that. So we got to try to avoid this wherever possible. So let's look at a particular claim. See, an inventor comes to you and he has a write-up. I have a camera that has a hologram in it. A smartphone with a hologram, I should say. All right. So we know about smartphones. We know about cameras and how they work. We know about holograms in general. The inventors insist that this combination is new and non-obvious. Okay. So here's an example of an independent claim. An independent claim is the broadest claim. It stands alone, hence its name. So we have a display, a memory, a user interface, and a holographic camera. All right, where the camera is connected to the display and the memory. Okay, simple enough. You may have dependent claims. These are claims that incorporate all of the independent and they add something. Like number 2, wherein there's a holographic image on the display. Or 3, where there's a holographic image stored in the memory. All right, and 4, where you add something. You're adding a transceiver to the smartphone so you can send it elsewhere. So you may go through the prosecution and come out at the other end with something like this. All right, the display, the memory, the user interface, the holographic camera, and the transceiver. The examiner says, if you have all that, I'll allow the case. So there might be some kind of compromise made during prosecution to get the case through.
When you're talking prosecution, Raymond, many of us, that might be overwhelming and sound scary. What you're talking about is, okay, we come to a patent attorney or an agent, we disclose our idea to you in confidentiality. We don't have to worry about you signing an NDA because it's already a given that that's right. And
I am, because of bar rules and things like that, I don't want to lose my license. I'm not going to pilfer your idea, Yeah.
So we go through that, talk to you about our idea, and then you help us to kind of fill in, or we help you to fill in the parts of the patent that you need to file. So all this, when you're talking about prosecution and all that, you're preparing the documents to put into the U.S. Patent and Trademark Office portal, where a patent examiner picks it up. After a certain amount of time, it gets assigned to a different group of examiners, and then they're the ones that are going to start digging into what you're proposing for our patent potential.
Yeah, after you file it, it enters prosecution phase, and where it's evaluated by the office. The office picks it up, and they look at the formalities initially, and then at some point down the road, an examiner reviews the application substantively to determine if it meets the 102, the novelty requirement, or 103, the non-obviousness requirement. So the examiner looks at what's called prior art, which is any prior patents that are related, any scientific articles, other articles, websites, whatever. Anything written that is available can be considered prior art.
And images, you said also, right? It could be. Yep. So that's why we can talk about all this and get to this point, and you go through all this. But that patent search in the beginning to make sure that there's no prior art, or if it is, how yours is different, and even the claims and everything else, what's making yours so unique and different. So sometimes I might come to you with something almost exactly what it is, but it might function or do something different. So you would also, and a lot of patent attorneys and agents kind of work around what's there so you can potentially get the claims approved for yourself, right?
Yes. I had a case with this lady inventor, and the invention was a rather simple one, but it's just a matter of articulating what it is that the examiner wanted, and it took a while, but I was able to finally articulate it in the way that the examiner wanted, and we got the case allowed.
Great.
But it was not an easy process. So there's a reason why you hire patent attorneys. All right. A lot of inventors, they try to do it themselves, and I understand that. You don't have money, and I sometimes get cases that are downstream of their initial filings and everything. And this one guy, he filed it himself. He prosecuted it himself. Went to the patent office. He says, I worked with that examiner, and the examiner was very helpful in me getting this case allowed. The problem, the examiner made him give away the heart of the case, but he didn't know. So then he starts to litigate the case, and he doesn't have as much meat on his case that he could have had. Now, could a patent attorney have done better for him? I would argue yes, because he would have known that he was giving up the heart of his invention. But because of the nature, the patent examiners, they're representing they're representing the government. They're representing us, as it were. They don't want to give you anything if they don't have to. So they asked him, "Hey, I'll allow it if you give up this," and he said, "Okay," but he didn't know. So anyway, enough of that.
Got it.
These are odd things with prosecution and everything. You hopefully get it through an issuance, and then you get your patent. Okay, you can have a family of claims. Okay, you don't have to have a device claim, system claims using the device, method claims, practicing the invention, or if you're in the chemical or biotech, you have composition type claims. Again, an inventor is the owner of the invention. If you have multiple inventors, each of them are co-owners. Okay, an inventor has to have a substantive role in at least one claim of the invention. Okay. Do not name everybody on the team. Oh my God. I had one time when they named all 15 people, and that's, not all people contributed to it. Their boss's boss didn't contribute anything, really. And this is the problem later on, because you got signatures and things like that. Now, 3 years down the road, are we going to find half of these employees? Are they going to be hostile to the company? Yeah, most likely. So anyway, only name people that are substantively involved. Okay, and again, inventors are owners at the beginning, but they may have an obligation if they're an employee to assign to, let's say, their employer.
So let's say if I'm the inventor and I end up getting into a licensing deal, or maybe I sell my intellectual property, I sell my patent. What I can do is I can assign, and I've had the opportunity to do this, assign my patent to that company. And during the time of my agreement, they're kind of assigned. They have the ability to work with my intellectual property. I will always be the inventor. That doesn't change, but I can assign it as I need to who I need.
Right.
Okay.
Yeah, and you may have obligations as an inventor, even though you've assigned it, to sign documents later on, but for example, if you get foreign cases and things like that. So there may be some downstream things after you've assigned all your rights. You may still have some obligations.
Raymond, sometimes inventors borrow money, or they have somebody that they're involved with them, or starting a business around their invention, and they haven't yet filed, and they put them on as an owner of the inventor. They add them as a co-inventor. So let's say I borrow money from you. I'm putting you on as an inventor. Is that something that I should be doing?
No. Again, you have to contribute substantively to the inventive concept. Just being the money bags is not enough. or in the case I was mentioning, just being the boss or the boss's boss of the team is not enough. You've got to be substantially involved into the invention itself.
Thank you. And I'm asking you these questions because I get these type of questions, and I appreciate you clearing that up.
I know I got a lot here. I got a bigger courses that I teach on this. Again, with the U.S. filings, again, just treat everything as absolute novelty, just to get a provisional on file so you don't lose your patent rights. Now, let's say somebody steals from you and files for a patent based on your idea. Let's say you signed an NDA or whatever, but they still stole it and they file first. Well, they have special proceedings now called derivation proceedings where you can get the inventorship back to yourself. Okay. But apart from that, if somebody else just files, you have the idea, but somebody else files before you, it's tough. You must file first.
And also, what I'm hearing from you also is if you are talking to somebody about your invention, it's always important to get that non-disclosure agreement signed by both parties.
Or just don't talk about it.
Or don't talk about it. But at the same time, when we come up with an idea, Raymond, we have this emotional excitement that we feel like it's going to change our life. We're going to make $1 gazillion, and we want to tell people about it, and we hope that who we're telling we can trust. But at the same time, whoever it is, if you have the documentation of a non-disclosure agreement in your back pocket that both parties signed, you're putting them on notice that they're not supposed to talk about your idea to anybody without your permission. And you're saying that that's something. So it's not in an envelope. It's not on your desktop, laptop. It's filing or having that non-disclosure agreement.
To be a part of the patent system, you must partake of the patent system. You can't just put it in an envelope and say, "Hey, I had the idea." No, that doesn't work. Okay.
And Raymond, just one other point to that. So let's say I do come up with the idea and I'm talking about it. I didn't file anything, but I do have up to a year when I publicly disclosed it to file. But if somebody else files before me, I'm out.
No, I did not say that. We used to have a grace period. We don't. Okay. We no longer have a. Technically, we have a grace period, but I mean, it is completely hazardous because somebody else can file the day after you talk about it, as long as but if they didn't derive it from you, all right? If you gave a speech and somebody in the audience said, "Oh yeah, that's great, I'll file a patent," no, that's derived. But a third party can file the patent, and it doesn't matter. You had the idea first, all right? You were slow to patent. And the patent office rewards first to file.
Thank you.
This is unfair. In my view, it's unfair because we had a first to invent system before, but we changed it with the American Invents Act. So there it is.
Okay. Thank you.
All right. So again, prosecution, there's a variety of things that can happen there. I won't get into all these details because of time, but you may have what's called a non-final office action, which the examiner says, "Hey, you got this idea, it's great, but it's not. I think this other reference is before yours. You don't have novelty." Or the examiner will say, "This other reference, and maybe two of them combined, renders your invention obvious. Well, you need to address this. You need to say, examiner, you're wrong for the following reasons." This may go back and forth until you get your allowance. Once you get your allowance, you pay the issue fee. And then the case will, at some point, become allowed. You may get a final rejection, but we have procedures to keep trying with a request for continued examination. And there's a variety of ways to keep the ball in play, so to speak.
Okay. Raymond, when we get that rejection notice, as inventors, should we panic?
No. Yeah, I was deposed on a patent a long time ago, and the other attorney didn't understand the nature of the patent system. They saw final rejection. They thought, "Hey, we got them now." And they said, "What does that say?" And I said, "It says final rejection." So it means final, right? I said, "No, in our system it does not, because you can file a request for continued examination to request it again, to re-request examination." Yeah, to the government, if you want to look at it crudely, it's just money. They just want another filing fee. Okay. And they're going to give you the opportunity to keep going. And typically, this is what happens sometimes. Typically, the examiners force you to do this. I don't like this at all, but they will give you a final rejection and make you refile the request for continued examination, and then magically it is allowed. Okay?
So out of all the patents that you file, what percentage you think get a rejection notice?
Most, because if I get once in a great while, I'll get an allowance on the first office action, just and I'm like, oh my God, what did I do? I left something on the table, So anyway.
So that's the point, is that for the most part, it might be something that actually did hit a brick wall, where it's practically the same thing, and there's a reason why you're getting rejected. So how much of a difference is it for you to have to justify, or they just might need a little bit of clarification just to get through it, to see it differently, because you're not having a conversation. It's just in your writing, in your words, trying to describe it and explain it, and not obvious and novel and all that. So for the most part, my experience is, don't panic. It needs, for the most part, patent examiners will provide what they're looking for the clarification or the rejection. And then there's a way around it somehow, hopefully. And if not, then the worst case is that your claim is removed, and hopefully you have more to protect.
I had a case where it was an elegant invention. It was about telephony. It was telecommunications, and it was clear to me that the examiner had no idea what the invention was. Yet he gave me a final rejection. So what I did was, I got the final rejection. I went to the patent office and I met with him and talked with him about it. He goes, "Oh, okay, yeah, I'll allow that." Yep. So anyway, you got to be aware of this kind of stuff. And if you're an inventor, this weirdness, you don't understand.
And sometimes there's also a chance, so you're communicating through the portal and going through the patent back and forth. But there's times where you can also request a patent examiner to get on the phone and have an interview. That's also been helpful.
It can be. Not all examiners is that way, but it can be. And again, once you get your patent, there's some duties after issuance, what's called maintenance fees, which are at 3.5, 7.5, and 11.5 years. And there are other procedures after you get the patent that to tweak it or to contest it. This is these post-grant review things with the American Invents Act, but I'm not going to get into that. Okay. Again, the claims are the enforcement part. This defines the scope of the invention, your right to exclude others and stop them from making, using, selling, or importing your invention, your claimed invention. You can provide notice of your invention by marking, and the right of the patent, it is imbued the day of issuance. It matures on that day. You can sue. It comes out, all U.S. patents come out on Tuesday. You could sue on that Tuesday if you wanted to. Okay?
But you cannot sue when you're patent pending.
That is correct. I'm sorry. Yes, you do. Your right has not matured yet. All right.
So when you mentioned provisional patent, that's just a filing date, from what I understand, right?
Yeah, provisional. That is to secure a priority date. An early filing date or priority date. Yeah. Okay. So anyway, why there's a higher, let's say you're in a company. Well, what can you do to help yourself? You want to get patents on your existing products, maybe future products of the company, future products of the industry. Maybe get patents on what other people that are your competitors are doing. Why? Because maybe you might get into a licensing situation or a litigation situation where they sue you and you say, well, hey, you're infringing on this other patent. And then you have a meeting of the minds and the litigation goes away. Okay? So other types of collaboration. So these patents can be tools at a corporate level for other things.
And even as an inventor, Raymond, so let's say I have an invention and I'm going to a company that has similar type of products and I'm looking for them to manufacture, to distribute, and for me to earn a royalty. So what I'm really doing is renting the rights to my intellectual property so I can give that company a competitive advantage. Most likely it's going to be exclusive because they don't want anybody else making the same thing. And those are the type of advantages that I have when I do actually have a patent. The other thing these days also with Amazon, for example, Amazon.com, you can have a product on there that you're patent pending or you're patented. So I could tell you that my situation, if I had patent pending, I wouldn't be able to do as much as I've done protecting my intellectual property, my patents, with a patent. So when I have a patent, I can show Amazon.com, I could show all these different online e-tailers or whoever's trying to sell them that I actually have an issued patent, a utility patent most of the time, a design patent. But if I didn't, then I wouldn't be able to stop those infringers. So in my opinion, look, some people say, get a patent, don't get a patent, it doesn't mean anything. But I could tell you that when I sell a product, if I have a patent, I'm confident that I can get them taken down for the most part. And if I don't, then they can make it and I can make it until I do get that patent. And like you said, that day you can enforce it.
Yeah, your right matures. And let's say you've assigned it to somebody else. Then I have on here exclusive licensee has the right to sue also. Either the owner can sue on behalf of the patent or the exclusive licensee. Why? But a regular licensee, a non-exclusive licensee, does not have the standing or the right to sue because there are others that have interests in connection with the patent. So it's only those that have direct ownership or been given that power, exclusive licensee, that can sue for the patent.
Right.
Okay, and again, there's a variety of reasons. Now, why is there so much controversy now with patents? Well, what's going on here? It used to be, when I was a beginning attorney and everything, 30 years ago, patents were a little backwater area. It wasn't all that controversial. It was important, but, it wasn't, critical or anything. Why is it critical? Well, look at this. This is the demonstration of how our society has changed since 1975. In 1975, 83% of a company's worth was tied up in physical things. All right? And I'm sorry, physical things. And only 17% was intellectual property. But look how that's changed. In 2025 now, you have 92% of a company's valuations tied up in intellectual property, 8% physical things, like land, equipment, whatever. If you look at Google, all their property they own in Silicon Valley, I'm sure it's expensive real estate, but add it all up, add up all the land, all the computers, all the jets, all this, it will just be a tiny fraction of the valuation of Google. This is the nature of our society now. And patents are the tools for this society. All right? This is why there's so much Supreme Court litigation in patent land. All right? Okay. This is because the stakes are so huge. Owning a little piece of this is critical. And big tech does not, they have fought a lot of battles to keep their dominance here. And they don't want upstarts, things like that. So this is why what we're talking about is so important.
Great.
This is one of the first slides when I teach the MBA program at George Washington. This is one of the first slides that I show, and MBA students would understand this. Okay. Oh, I'm sorry. I think that's the end. But like I said, the patent process is, there's got to be a reason why you're patenting. You're going to be going down a road that has consequences. It's going to have financial consequences. It's going to have other consequences. But if it's important to you, this is the manner of how to get it done. All right. And if you have any questions on that, please feel free to reach out to Brian or me to answer any further questions on it.
Thank you, Raymond. Appreciate all the information and really digging into what a patent is actually there for and how it can help and support us and build intellectual property assets for us. So you're working for many years. You're right there in Washington, D.C., right by the U.S. Patent and Trademark Office in Alexandria, Virginia. I know there's other offices all over the country, but that's headquarters there. You're working with corporations, mid-sized, large, small companies, startups, entrepreneurs, inventors. You've kind of been around for a while and seen a lot of things happen and protecting your intellectual property, infringing, people be successful. Maybe you can share some final words of wisdom for us. Some of us are stuck just with our idea in our head. Maybe we didn't file, maybe we're thinking about filing, or we filed, or we're successful at this point with our intellectual property. If you could share some final words of wisdom for us, that would be great.
Okay. The patent process, again, when I started, it was a quiet area. And then it's heated up with the internet, with the creation of the internet in the 90s, and then smartphones and all these other things, more and more abstraction. And it's only going to get worse and worse and worse in that regard. So there's plenty of innovation out there. And the human mind is an infinite thing, and it can perceive infinite things. We are all creators. But with an idea to have commercial value, that is the thing. And the higher the degree of commercial value something has, the more you need to protect it. Now, with the America Invents Act of 2012, they've cut back a bit on the inventive process and things like that. It's created a lot of problems, which I won't get into. But with the new administration and the new director, John Squires at the Patent Office, and the Commerce Secretary, Howard Lutnick, they have made a priority of rejuvenating the patent system in the United States. So if you have any ideas on the patenting, now's a good time to seek these ideas.
Thank you so much. Raymond Van Dyke from Van Dyke Intellectual Property in Washington, D.C., sharing his knowledge, wisdom, and advice to us. Thank you so much, Raymond. We appreciate you and the support for the inventor community. Thank you for this great info. We'll see you soon.
Thank you.
Welcome to National Inventor Club. My name is Brian Fried. I'm the founder, and I always bring interesting guests for us, especially this one. His name is Raymond Van Dyke. He's from Van Dyke Intellectual Property. And Raymond, I get asked quite a bit, you know what? I got this patent. I'm thinking about getting a patent. I looked at patents on U.S. Patent and Trademark Office website, or I saw somebody else's patent. And that is a lot of information all bundled up into what my simple idea could be, or maybe it's complex. But today you're going to share with us what all that means. So thank you for joining us. You mentioned that you are a patent attorney in Washington, D.C., Van Dyke Intellectual Property. Why don't you go ahead and tell us a little bit about yourself?
Well, thank you, Brian.